Hi, welcome to One Fix. I'm Rob Leathern. My guest today, Ben Edelman, has spent 2 decades catching online fraud that hides in plain sight, combining software engineering, law, and economics to prove misconduct empirically rather than take companies at their word. In this conversation, we get into the Phia shopping plugin scandal, how it relates to Honey and PayPal, and something that he covered after MegaLag broke the issue on YouTube, the mechanics of affiliate fraud, and his recent investigation into AppLovin's apparent app install deals with mobile carriers. You won't want to miss this one. Thanks for joining us. Hey, Ben, how are you? How's it going? Where are you? Where are you joining us from?
I am actually in Tokyo today. My kids said they wanted to go somewhere hot with good Asian food, so this place fits the bill.
Nice. I'm in San Francisco, so both of us are not in our normal locations, but I thought it'd be really great. Thank you for taking the time. I just wanted to catch up. You can tell us a little bit more about the context of this recent investigation, but I also have wanted to just chat to you at some point on this new podcast that I started recently. And so I'm glad that you were up for it.
My pleasure. Thanks for thinking of me.
Maybe, by way of introduction, so tell us a little bit more about how you got into these kinds of investigations, and then we can talk specifically about Phia and that whole set of shenanigans, which, I think, again, there's some really interesting learnings from. But tell us a little bit more. How did you get into doing what you're doing in the first place?
Yeah, I guess my story with respect to ad fraud begins in 2001, not a typo, when my clients, the New York Times, Washington Post, Wall Street Journal, and a bunch of others, there were 7 of them splitting the bill into several equal parts, wanted to sue a company called Gator. Gator was Adware. Maybe it was the first Adware, the most famous of its day. At the start of that litigation, Gator was looking in web pages for 300 by 250 banner ads and also 160 by 600s, and they had a couple other sizes. And they would reach into the publisher's website, take out the banner ad, substitute their own banner ad, which they had sold through their sales force. The publisher would get 0 for their hard work of paying journalists and editors and health insurance and the rest, and Gator would keep all the money. So nice little business for Gator, not good for my clients. We got that shut down for my clients, and for the rest of the world, well, they hadn't hired any lawyers, they hadn't hired any technical experts, so they got nothing. That didn't work for me. I kept working on Adware, made a little business of it for a while there, and on some level, I never stopped. This is sort of the culmination of that, and I suspect not the last chapter in the book.
I remember Gator very well. I wrote about them when I was a research analyst at Jupiter, and I called that category of things sneakyware, because yes, I think adware is another way to put it, but it was everything they did was kind of sneaky and tricky, and it was hard to uninstall, or maybe impossible, perhaps, depending on your definition of uninstall. But yeah, that whole category of adware was, I guess, a dark chapter, but then, it recurs in many different ways, I think, and brings us to the present moment, doesn't it?
It was a dark chapter for some very famous VCs. I have a page on my site. I can give it to you to put in the show notes, where I chronicled which VCs had funded which adware vendors in which amounts. I think all of those investments were terrible. They lost a lot of money on it. I wish I had been in a position to advise some of them on why they should keep their powder dry. Those adware companies all failed, so that's good. The long arc of the story does bend towards justice, as has been said, but it can take a while to get there.
Yeah, absolutely. I mean, I remember the category. What's that other category? Deep packet inspection companies. That was another, dark VC funded chapter in the story, wasn't it?
There are to this day some that will modify Wi-Fi in, say, coffee shops, hotels, airports, places like that, so that when you request Expedia.com, it doesn't bring you to Expedia.com. It brings you to an affiliate link to Expedia. And if someday Expedia ever kicks out one of those companies, they can make Expedia unreachable. Sorry, this coffee shop doesn't support Expedia. Would you like Booking.com? So it's just nuts, the things you can do with deep packet inspection.
Yeah, I agree. That's maybe a story for another day. But I think you mentioned the affiliate side, and so tell us a little bit more about this investigation, about Phia, and how you found this, and your interactions with journalists who wrote about this as well. I mean, I'd love to just understand how, you got involved in this, or what you saw, and how. Tell us a little bit more about that.
Right. Well, I retired from big tech almost 2 years ago and decided I wanted to work on things that really mattered to me and have more control over it. A decision that rings true to you too, I'm sure, for broadly similar reasons. I wasn't originally thinking I'd get back into affiliate, but when the YouTuber MegaLag had this amazing series on honey, well, I started communicating with him after the first video, which was good. And together we did the work that's in his third video, which I'd like to think is better than good. That got me looking at the other shopping plugins too. In some respects, shopping plugins are so much better than they were circa a decade ago. And we can talk about what has improved in this industry. It's nice to have things to celebrate. And then some other things are just totally messed up. It's like there's, no one guarding the hen house and the fox lives inside the hen house at this point. So the Phia was on my radar when Bloomberg contacted me saying they were looking at certain problems by Phia. I said, well, that's interesting, but I've got some others. Let me tell you about those too. And next thing you know, we had the story that everyone looked at a couple of weeks ago.
So I think this is similar to the honey case in that it's basically claiming credit for transactions that the partner did not drive. It's kind of writing over other affiliates' cookies. I think is that the right way to think about it? Are they similar, or what's different about the two cases? Or are they just generally the same variants of different variants of the same thing?
Well, they're both breach of contract, where the governing rules are embodied in a contract, which Phia and honey are privy to. The specific violations are partly the same, but Phia has more violations. Maybe honey has some aggravating factors too, in the way that they tried to hide what they were doing to avoid getting caught. As to Phia, my article lays out two separate violations that I want readers to understand. The first is a forced clicks violation, which hurts the merchant. The second is a stand down violation, which hurts other affiliates. So those are different practices, different harm, different likely dollar value of impact. In general, forced clicks is a higher dollar value attack than stand down violations. Both are bad. It's breach of contract is breach of contract, but breach different parts of the contract with different victims and different amounts at issue.
Is one way to think about it? I always try to figure out what good analogies are for explaining this stuff to regular folk. Is it kind of like you're at the store and this, you go to check out and the salesperson comes up and says, "Hey, can I just add my code to your checkout to get credit for having helped you when they never helped you like navigate the store or pick out items?" Is that the way to think about at least part of what you're saying?
Yeah, that's sort of the classic forced clicks violation, where the salesman is at the very last step when you're already sold, putting his code in. You describe a salesman who is asking, but in this case, there's no asking. It's entirely invisible. You'd never know that it happens unless you have some forensic skills to test. Obviously, if you know just how to test, you could find software to help you test and to prove it. But just slipping your code in, it's as if the cashier in the grocery store or whatever store, the cashier in the store was also slipping in the code of the cashier's friend, the salesman, and in so doing, goosing that salesman's numbers. And to be sure, it's not a victimless crime, right? That means that a bad salesman can be reported as a good salesman, win the trip or the bonus or whatever it is that the boss is giving out, and take more commission from the boss who should have had a certain number of transactions that are not credited to any salesman. This store has a good reputation. Customers come in and they buy stuff. And it really is true for e-commerce retailers. We already advertised on TV, on the sides of buses. We have such great product that there's word of mouth. Stores counting on those things. That's part of how they make the numbers work. Not every transaction should be commissionable to an affiliate, but forced clicks takes those commissions even when they are not fairly earned.
Yeah, and it sounds like the Phia's response to this was to say, "Oh, it's a bug." So I remember, there's some cases I can't talk about, but in my experience, I remember one case where we met with a company that had done something when I was at Facebook, and my colleague said, "Watch, I bet within the first 3 minutes they will throw some internal team under the bus and say it was a bug." And honest to goodness, that is exactly what happened. And so I'm curious how you feel, what you think of the company's response and the credibility of claiming this was a bug and they fixed it. And what are your thoughts on their response to this whole thing?
Well, there are multiple levels of their response that don't convince me. Maybe the easiest to debunk was their claim that this was very recent. They said that it was in a recent build, and that they're suggesting that this was just a matter of days or weeks that the problem was in effect. Now, every old version of an app in the Chrome plugin store is preserved. So you can go back and you can download the CRX of a historic version. A CRX is a zip file, so you can unzip the CRX and you can read the code. It's minified, but if you're smart, or you know an AI that can read minified code, or you have some other strategy, you can just find the first version that had it. This is not like a good thing to lie about, to say it was recent, because we're just going to go and get the old versions and see how recent it is. And by doing that, you quickly find that it's December 2025. So that's like right in the peak of the holiday season, right? Not particularly recent. I mean, compared to some things, you want to date back to Windows 3.1 or Tyrannosaurus Rex, it's all recent. But relative to e-commerce, right? Relative to Chrome plugins, relative to Safari mobile plugins, it's not that recent. Okay, but then as to intentionality, bugs have a way of looking, and intentional misconduct has a different way of looking. When you see someone make a quote-unquote mistake or a bug and it's totally self-serving, you don't tend to think it's a bug. You tend to think it was an intentional decision for their benefit. If I see United Airlines sell a plane ticket for $1, I say, okay, that's got to be a mistake, right? This plane ticket is usually $100 or $1,000. Maybe they missed 2 zeros. And if you see them try to sell a plane ticket for $10 million, you have to say, well, that can't be right. No one pays $10 million for a plane ticket. You just buy your own plane and fly where you want to go. It's got to be a mistake. Those are two bugs that both redound very much to their detriment, right? The price being too low leads to a bunch of fighting. Probably you don't actually honor it, but get lots of angry customers to deal with. Price being too high, you don't sell anything, and eventually you're going to notice, why is no one buying seats on this plane? Versus this bug, it's a very convenient bug. It's only in the version of the software that no one looks at. No one really tests the Safari extension all that carefully compared to the Chrome extension. It's invisible. It has no on-screen manifestation, and it makes them a bunch of money. It probably 10x's their revenue on the users who are on Safari mobile. So that doesn't look like a bug to me. Eventually, I guess we'll find out, right? It only takes one company suing them, one network demanding the documents for the intentionality to be revealed.
Yeah. And this isn't, I don't think this was the first incident that they had. When I was just looking online, it looked like there was a bunch of stuff that came out late last year around them taking screenshots from within the app. Is that something you can explain a little bit to folks about what your understanding of what occurred there?
Right. It's weirdly simple. Screenshots are screenshots. They were taking screenshots and of sensitive information that people wouldn't want screenshotted. Maybe that could be understood as sort of unintentional. We just take screenshots of everything, sensitive or not. Was it in the privacy policy? Was it disclosed? I haven't checked that. I don't have a good feeling about it. But even if it was, it seems so totally unnecessary, right? For a shopping app, classically, you'd need to know what products I bought and what products I looked at but didn't buy. And from that, you make your recommendations. You do not need a screenshot of what's on my screen, what YouTube I'm watching, what emails I'm sending, what my insurance company says about my recent doctor's visit. Those are all things that are going to be on my screen. They're all not important for a shopping plugin. They're sort of radioactive, right? You go and collect that and everyone's going to be angry at you when they find out. It looked like kind of a dumb product decision to me. Like a sophisticated, experienced team just wouldn't do that.
I feel like we're at a very dumb part of the tech cycle right now. So there's a bunch of apps that take screenshots. And I mean, even the way some of the foundational models operate is they'll take screenshots of the screen and then analyze it to try to see if they did the right thing or to try to figure out what's on the screen so they can manipulate, instead of the harder work where they're like, oh, well, wow, I'd have to, if I had to look at the actual files and had to figure out what's on the page, or like what, it's so hard. JavaScript is tricky, all these things. So I feel like we're at this kind of lazy part where we're like offloading, well, not only are we offloading our brains to AI in many ways, but we're offloading a lot of these things and then not worrying about the sensitivity of what might be on the screen, or frankly, just the fact that these are highly inefficient ways to do some of these learnings or to train these models on things. I was using or looking at Whisperflow, one of these, voice apps, and they disclose it, but a lot of people who I spoke to using it didn't realize it. It takes screenshots of your device in order to figure out if it's doing the right thing. So I just think some of the trade-offs we're making with respect to efficacy versus privacy are just way off right now.
Certainly, I was going to go right to efficiency where you did in second half of your remarks. The efficiency aspect of it, reliability too, accuracy. When you build a robust data pipeline, it works. Maybe something could get messed up. Someone could change a field name, change the structure of the payload. But short of that, it's efficient. It's reliable. There's just so much to be said as to the goodness of building something right. Versus when you work on screenshots and the hackiest of hacks, you're consuming compute time, you're inflating your payloads, and your reliability drops too. I'm just not a fan. I guess I feel like an old guy sometimes. In my day, we built things right. We built our buildings out of bricks, but we try to build it right so that it actually lasts and is reliable and efficient to use.
It seems like there's this recurring theme that you talked about how you started your work around Gator and essentially client-side software that's sitting there looking at what you're doing and then deciding the right time to insert an ad or pop up a message or whatever. Now we're talking about 2026, 2025, 2026 companies doing essentially the same thing by other means. Tell us a little bit more about how where you see this category of kind of assistance or shopping help or other things. Is this an area where we're just going to have to always be watchful? And how do you think about this category of things in 2026 that we're talking about?
Well, I've been not a fan of shopping plugins, back to, I guess, IE6, when there were EXEs that would hook into Internet Explorer and manipulate the DOM in order to do much the same thing that Phia is doing. I was not a fan then. I'm not a fan now, first and foremost, because I don't think it adds value for merchants. It's one thing for a merchant to say to a shopping website, look, if you want to pay the affiliate commission out to the user, as, say, FatWallet did 20 years ago, you go to fatwallet.com, you click their link to Dell, and Dell pays a commission to FatWallet. FatWallet rebates most of that to you, the user, maybe even all of it, and makes its money some other way, advertising or float or breakage. I like that. I was a satisfied FatWallet user. I was sad when they shut it down. These days, there are some other companies doing much the same thing. And when it's done on the web, such that the user has to remember to go to that site and click the button, there's a reasonable inference that the user actually is influenced by it. The user wants the cash back enough to remember. And so is it incremental to the merchant anyway? The merchant is able to separate the price-sensitive customers from the non-price-sensitive customers and encourage users not to go through expensive paid search. So, okay, fine, that works. But make it automatic. Put a shopping plugin in the user's computer so that they always go through. Suddenly, it's not that good a deal for the merchant, right? It's turning every transaction into a commissionable transaction. That is good for the affiliate manager trying to make his or her numbers. Boss, my numbers are up 50% year over year. Can I have a bonus? And it might be good for the head of interactive marketing, who looks even more important. Our marketing budget has gone up, and I should get more headcount to manage the higher budget, and I should get a bonus too, no doubt. But is it actually good for the shareholders? And on that one, I guess I was sour on it 20 years ago, and I'm still sour on it today. There's all kinds of people who want to say that it works. The affiliate managers, the head of interactive marketing, God knows the networks have mixed incentives on this too. They're marking up everyone's commissions. If I owned a company that had an affiliate program, I would not be in any great hurry to allow the shopping plugins in.
Yeah, I think the incrementality is so hard to measure, and I guess also part of this problem is that I myself have been conditioned whenever I'm about to check out and I see something that says coupon code on the checkout page. I'm like, oh wait, am I a sucker? Should I be getting 20% off here, or should I have signed up for the 15% off for your first purchase? I get so many things where I would just want to buy the thing, but now I'm like, oh, have I missed something? So I think we've also been conditioned as consumers to be looking for deals all the time, and sometimes that obviously leads to bad places.
Yeah, the coupon code box is paradoxical. Not exactly a fan of it, though I don't have an alternative to suggest.
one of the things that's just about online shopping as well, I think it's also tricky just to figure out who a good merchant is. If you're only relying on the context of if it's someone you've never bought from before, and so I think there's a lot of challenges around online shopping. I've seen, for example, one of the things someone brought to my attention recently was these AI generated images of products that don't exist. And, then you order it, it takes a few weeks, you get something that is nothing like what was described in the AI generated imagery. And so it just the time delay of shipping stuff to people also allows a lot of shenanigans to slip in, unfortunately.
Yeah, I haven't worked on that, but I can imagine, and it doesn't sound great. We are so spoiled by the marketplaces that make it easy to get goods at ridiculous prices. You look at some of the prices from, maybe I don't need to say the name, but marketplaces that give much cheaper stuff than you get accustomed to from an Amazon, right? And is the quality there? What is your recourse? If it isn't, it can be kind of messy.
So this investigation, obviously got a lot of attention. I think part of it is probably because of the fame of the founders in this particular case. I think it's kind of this Silicon Valley truism, fake it till you make it, which I think is an unfortunate but real thing with startups. The Honey case, I think, was more surprising. It was surprising to me in many ways because this is a publicly traded company, and the dynamics feel a little bit different. Any thoughts on that kind of, is it the case that publicly traded companies are better behaved? What are maybe this is starting to get into the broader view of the kinds of investigations you do or things that you think about. But do you think that it's true that startups are the ones, playing loose and fast with the rules, or do you think there's plenty of, bad behavior to go around whether the companies are publicly traded or not?
I haven't been shy in criticizing the very largest companies, including publicly traded companies valued now in the trillions. If they weren't at the time when I was most intensely looking at them. In general, you see a slightly different kind of misconduct from big companies versus small companies. When I was criticizing Google, for example, it was certainly clear that lawyers had their way with all of the areas that I was thinking about. Lawyers were the perpetrators of some of it, some contract that seems like it's intended to obstruct competition and to prevent competitors from getting a toehold. And I think with the benefit of discovery and further litigation, we know that that's exactly right, that the lawyers designed a bunch of these contracts thinking that they were at the edge of what was legal, but, legal enough. And anyway, if we have to pay $1 billion fine someday, it's still a small fraction of the benefit we get. So that big company shenanigans, and we could talk about exactly, the typical contours. Honey was paradoxical in that it's sort of using small company tactics, despite, as you say, having grown into a big company. We got the source code that implemented Honey's shenanigans, and the source code presented in detail, color-coded highlighting, the kind of article that I love to write, and I hope readers expect from me at this point. It's nasty stuff. They're saying, okay, we really want to ignore the stand-down rules. We want to say that we referred the user, even though someone else has already referred the user, but we can't get caught. So let's look at this user. Who is the user? Is the user's account more than 30 days old? So we don't want to break this rule on anyone in their first 30 days. It could be a network quality tester who is looking for violations. Does the user have at least 5,000 points? Later, they raised it up to 65,000 points. These are pretty big numbers. That's like hundreds of dollars of commission earned, of rebate value through the Honey platform. What tester would ever spend, $5,000 in order to earn $600 of commission? You'd have to be crazy as a tester. Where you can get the budget to buy $5,000 of stuff just to test Honey? Fortunately, it's possible to fake your points and then see what it would do if you had such and such many points. These are the tactics of a small company that, wants to break the rules, doesn't want to get caught, wants to hide from the testers. It wasn't smart for Honey, and now they're going to pay a price for it. Already in litigation, they take the position that, this is legacy code. They didn't exactly do it. The old people did it, and that isn't quite convincing based on the facts that we can prove as to the code being modified and certainly the parameters for the code being modified.
Sure. I mean, there's due diligence. If you're acquiring someone, aren't you supposed to look at the code and figure out what the people do and how everything works?
Yeah.
Seems like
Well,
you got a job you
that
should
too.
do.
Yeah,
Yeah.
certainly in a diligence process, but separate and apart from that, during the period in which PayPal owned Honey, the configurations were changed. So who changed them and why? They're all raised as if the code was getting more compliant. They were tightening the requirements rather than being willing to violate stand down. If a user had just 5,000 points, for example, they raised it, I mentioned, to 65,000. That's a big change. Whose decision was it? But it must have been a PayPal employee's decision because it happened really years after the transaction.
The thing about the Honey that's also super interesting, I'd love your comments on, which is that, you know, the MegaLag YouTube videos, super engaging, really interesting. In many ways, like, I think they're now, you know, and again, folks like Bloomberg and others do great work, but I feel like, you know, you have a much more creative space to explain what's going on to people and to get, you know, some combination of distribution, viral sharing, and outrage going online in some of these other forums. So I'm curious how you feel like that kind of thing is evolving for this type of work, because, you know, would people have cared about Honey if it was an article in, you know, some publication simply? And because, you know, a lot of these things, there's some great work that's done, but the fall off of people actually caring or paying attention just seems very steep.
Yeah, I certainly have work that I did that I felt didn't get as much attention as it deserved based on its technical merit or substantive merit, and maybe other work that seemed to get a lot of attention relative to the ultimate importance of what it was all about. So media can be a rough justice. MegaLag is a beast. I mean, the quality of his production, the amount of time and care he puts into it, he deserves every bit of recognition that he's gotten and deserves every good thing that comes down the pike for him. He made the first video not as an expert in affiliate marketing. He gets a lot of credit from me for bravery, putting himself out there. The video wasn't totally perfect. There were parts of it that were kind of messed up, actually, and that's okay. Perfection is not the standard. By the third video, the guy really knows what he's talking about. He knows the affiliate marketing business, and just imagine all the things he has that he hasn't put into a video yet. So big admirer, much respect. I like to see this work done by everyone who has an angle on it, who has any economic incentive to keep doing it. There's certainly plenty of work to be done and no shortage of it. If Bloomberg can somehow find technical people to do it in-house, and note the byline on the recent Phia article, 3 people, 2 of whom are quite technical, that's amazing. I mean, more credit to Bloomberg to find and manage and retain and pay those people. Otherwise, it'll be people like me and MegaLag doing it as a hobby, maybe scavenging together what revenue we can from it.
Yeah. So you know, I feel like this area is really interesting. I mean, there's a lot of folks like, you know, a lot of people I know, for example, who are on the fringes of privacy, security, trust and safety teams and so on, who also, you know, like more independence, but I think have a lot of technical competency. So I feel like there's a combination of, you know, working together, folks who have a platform, whether that's, you know, old media, new media, whatever it is, along with technical folks who can help do investigations or complement that. I think there's got to be some model there that is durable and sustainable in the future. But, you know, again, what it exactly is, maybe it's affiliate revenue that sustains it. I'm just kidding. It's probably not. That wouldn't be my first choice anyway. So
yeah, it's interesting to think. You know, if I made a shopping plugin or a shopping site, how would it be different from the others? Anyway, that's not a plan I've been thinking about.
Yeah. So speaking about other investigations, you know, it sounds like, you know, there's some that go well and get a lot of attention, and you know, obviously you never really know what's going to catch people's attention in the public sphere. But what are some of the ones that you think are maybe still important, have been frustrating, or where you feel like there's more to be uncovered? Are there any that you're able to talk about? I mean, again, I know some of these, there's always stuff where some stuff's litigation, some stuff's other stuff. But what are some things that you've been frustrated that haven't gotten the purchase that maybe you expected they would?
Well, I wrote up a quick piece on stand-down violations by Microsoft Edge in fall 2025 before MegaLag 3 broke. Really, no one noticed the piece. I mean, it was slightly pathetic that I write about violations by what was then, I think, maybe the second most valuable company in the world, and in a browser that is shipped on your computer whether you asked for it or not, in a shopping app that sort of gets turned on whether you wanted it or not. And then it doesn't even follow the stand down rules. Microsoft said it was an accident or a mistake. ish. They sort of said it. It's not like there was a ton of media coverage requiring them to respond. Anyway, as someone who had recently worked at Microsoft, I was kind of unimpressed by the whole thing and wondering who's even running that team, having seen it turn over a couple times, even in the period when I was there. More generally than that, let's see, typo squatting. I've always been a big skeptic of typo squatting. Of course, I was co-counsel in class action litigation against Google. As to Google's role in funding typo squatting, Google was paying the typo squatters. We said that Google was, quote unquote, using the typo squatting domains. The language under the ACPA is that you can't register, traffic in, or use the infringing domains. And we said, okay, Google didn't register them, but they seem to be trafficking in them when they bought the traffic. What does trafficking in it mean other than buying the traffic? You have to buy the thing rather than the traffic from the thing. But anyway, they certainly used it when they bought the traffic from the thing. We said Google should be liable. The court said each trademark holder will have to sue Google separately and independently, which obviously is never going to happen. Either they get one set of lawyers and do it all together, or it doesn't get done at all. So the judge basically chose doesn't get done at all. That was heartbreaking. That was also more than a decade ago, so I've had my time to get over it.
It's funny. I was at an ad tech conference recently, and a founder, one of the founders that I know there, was saying it was basically like sharing his frustration that good work that they're doing at his company is basically just getting undermined by other companies because I think ads is the whole ads ecosystem is one that's very poorly understood. Especially by media, because media also has an interest in it, in ads, and so they've actually tended to shy away from covering it very well. So, do you think that that we just need more understanding of ad tech and ad related and marketing related technologies? Do you think that's realistic? Do you think it doesn't matter that much? Because one of the things that bugs me is that there are hundreds of billions of dollars flowing through these companies, but the amount of attention or that's paid relative to what share of the economy that they occupy just seems really low. Do you think I'm off in that sense, or do you think there's something there?
There's been greater attention on Google and on Meta and Amazon and Apple from antitrust folks over the past 10 years. I guess I feel like I was right on that, right? I was very early to the party of saying Google was an antitrust villain, and I was booed out of classrooms and off of stages. Maybe not literally, but, if they could do it to me through teaching evaluations or invite this guy back to the next iteration of this conference, I certainly made myself an unpopular fellow in a bunch of audiences and didn't really care. I wanted to say what I thought was true and figured eventually the world would come around to see it the way I did, which was right. Amazing. I'm so glad is, the ultimate I told you so moment when the United States copycats something on my blog, which literally happens, right? Like I blog about something and then antitrust regulators on a couple of continents years later sue Google over exactly that. Very, very satisfying in an ultimate I told you so kind of a way, and also totally worthless in terms of money in the bank. There are specific instances where things really don't get the attention they deserve. Most on my mind in that regard is AppLovin. AppLovin, because it's not a household name, they don't have a B2C personality. They're just in a B2B context. I pitched the Wall Street Journal on an AppLovin story, and Wall Street Journal said, no, we don't cover those guys because they don't market to consumers. I said, I'm sorry, don't you cover finance, like companies that make things that are traded on stock exchanges, and your readers as sophisticated investors want to know whether the stuff is what it's supposed to be? Anyway, credit to Bloomberg, actually the same journalist who had the Phia story, Olivia Solon, had written a couple things about AppLovin, so I pitched her, and she covered some serious AppLovin misconduct that I stumbled into last year. But no one else wanted to. Blew my mind that Wall Street Journal not only wouldn't do it, but wouldn't do it for that reason and would state the reason. They should have just told me, sorry, too busy, and I would have thought the better of them versus what they actually told me.
Yeah, I want you to talk a little bit more about AppLovin. When I read some of the stuff around it, what it reminded me of was Cheetah Mobile, which I was involved with. I worked at Facebook at the time when they were removed from Facebook and then later Google. Obviously, I can't talk about the specifics of that directly, but what I can say is they disclose that in their public filings. And the initiation point for that was a report by a company about them stealing attribution credit from other companies, allegedly, and then an article in BuzzFeed and so on that also talked about that. So I do feel like the combination of deep research by obviously folks who have an interest in this area, journalists who I think are very competent and covered the stuff well and have a good technical understanding, and companies then looking at the data and doing their own investigations and holding companies accountable. Again, we presume that is what happened in all of these cases. Work there. So can you talk a little bit about AppLovin and what you've seen, or to the extent you're able to just give a high level description of what you think is going on there?
Yeah, well, there are multiple aspects of AppLovin's business that are of concern, and I have hypotheses about multiple parts of their business that I'm skeptical about, including attribution, maybe lead stealing, taking credit for other people's leads. But I couldn't prove any of that to my satisfaction, and haven't in the subsequent 6-8 months made any progress on any of that. Where I did make a lot of progress and proved very much to my satisfaction was looking at what's called an install helper, a relationship between the AppLovin code in the SDK of an app, typically a game, and some other piece of code that's preloaded on a phone or tablet or other device, typically by the carrier or the manufacturer. And what happens is that AppLovin is able to use that preloaded, super privileged piece of code to install stuff onto the user's device without the user agreeing to it. So you're playing game A, up comes an AppLovin ad for game B, and next thing you know, game B is installed on your device without you tapping, without you seeing anything in Play Store. In some implementations, they'll have a countdown, 5, 4, 3, 2, 1, we're installing it. You say, wait, that's not how it's supposed to be. This is Android. It's super secure. I have to press the magic button and only Play Store can show me the button. But they found a way around all of that. So I went through their source code, which was, it was a real heavy lift for me anyway. Someone smarter than me could do it more easily. It was 600,000 lines of code, heavily obfuscated. This was compiled Java code, except Java is never really compiled. It's sort of pseudo-compiled. All the string identifiers got messed up, so the function names were all turned to gibberish, the variable names. But still, when they call an Android core function, I can see that, and had some AI that helped me, though I had to check every step of the work to make sure it was right. Bottom line is I traced the execution stack from showing the ad through to installing the app and put all the work on my website. Bloomberg published it, but published it as a he said, she said. Edelman says that they're doing this, and AppLovin says they always get user consent. I don't know what they meant by consent, like 5, 4, 3, 2, 1. Doesn't seem like if that's consent, there's going to be a whole lot of consenting going on once people find out that that'll do. Anyway, no one piled on. There's litigation about it that I'm not part of. They cite my website. That's nice, I guess. No other media publication jumped in to get to the bottom of it to ask AppLovin, what do you mean consent? Are you saying 5, 4, 3, 2, 1 is consent? Did you always do 5, 4, 3, 2, 1? Did you sometimes do it not 5, 4, 3, 2, 1? Just install it in the background? I went through the code, so I can see all the forks in the code and the different things it's capable of. Anyway, no one was interested. Maybe this podcast will be the thing that gets some, ambitious journalist to want to get to the bottom of what happened. It was only last year. It's not time barred. It's still very much in scope.
Still very current. Who would allow something like that? Is that essentially the handset makers would have some deal, presumably, with the company to allow those pre-installs to happen? Is that kind of like the old, junkware on your, PC or whatever? Is that similar way of thinking about it, or is it something different?
Yeah, I think it's kind of like that. Samsung and T-Mobile were the two big U.S. names. Samsung, obviously, not based in the U.S., but widely known by American customers. They both had preloads on devices that they were marketing to American consumers. In other countries, there are carriers that are pre-installing AppLovin software. It only takes that little preload for AppLovin then to be able to flip on all of this capability. I never really was certain to what extent the carriers and manufacturers were victims here, that AppLovin had told them one thing and was doing something quite different, versus were participants happy to throw AppLovin under the bus, but also happy to collect their rev share for as long as possible. I still don't know. Again, a good opportunity for a journalist to get to the bottom of it, call the people in T-Mobile business development and run it down. And so too for Samsung and Oppo and on down the list. And I gave the names of the leads, which I extracted from the code, because the code separately lists each of the companies that AppLovin had a partnership with. So it's quite the source for journalists.
I think if speaking historically, carriers have been very happy to take large rev shares from very questionable business practices. I mean, I'm reminded of the direct billing, 10, 15 years ago where people were installing or get 10 free ringtones, get, 10 free crushes or whatever the social media dating nonsense was. And then it starts billing them, $10, $15, $20 a month. I mean, some of those practices I think are worse now, but in some cases they've been curtailed via various, lawsuits and other things, being levied. But the whole direct billing space was always a nightmare and kind of showed the willingness of some of these companies to just, as you said, take the money. So
right, carrier billing, where customers typically didn't understand that they could dispute those transactions, maybe even more easily than their Fair Credit and Billing Act disputes with credit card charges. You could dispute a carrier direct billing charge pretty easily, and it would just go away. But some people didn't know that. They thought, oh my goodness, if I don't pay my T-Mobile bill, I'm not going to have T-Mobile service and my phone number won't work anymore. So I guess I have to pay. They swindled me fair and square. There was amazing litigation, and I guess I immediately jumped to Google. I wrote about this a decade plus ago, but Google was deep in bed with some of these companies for whom the main expense was paying Google for the ads to sucker the users in. So Google was sort of a majority partner in some of these companies, extending credit to them as an AdWords advertiser that could be trusted to pay their bill, but why not extend the guy some credit so we can ramp up even faster? It was just insanity to me. Not a fan.
That's frustrating. So are there things that you would recommend just from a policy perspective to create more accountability for these kinds of practices, or obviously I think continue to do the investigation and so on, but without kind of, often there isn't a private right of action. Some of these companies have, click wrap terms that require arbitration. There's a lot of nonsense on that side of it as well that we probably don't have time to get into in too much depth. But what do you think is a series of accountability steps that could help consumers in these kinds of cases?
Well, first, the click wrap stuff, the class waiver and arbitration clauses, those are a disaster and embarrassment to the American legal system. What would Ben Franklin say? I love that guy. I love his writings. It's a good guidepost to ask yourself what he would say, and he would not recognize this as any judicial system he wanted to be a part of. But separately, it's interesting to think who that doesn't bind. It doesn't bind the Attorney General of New York or California or Oklahoma. All of those states have serious, ambitious attorneys general who want to do good work, want to see their name in headlines, want to do right by the citizen taxpayers of their respective jurisdictions. I would like to see one of those attorneys general pursue AppLovin. I mean, why the heck not, right? You were putting junk onto my constituents' phones with 54321, or maybe not even that, and you were profiting from it. We want the money back. Why don't you give each user the money that you got, 100 cents on the dollar plus interest at its prevailing rate? If you charge someone $6 to put something on Rob's phone without Rob agreeing to it, give me, the Attorney General of Oklahoma, the $6 and I'll find Rob and I'll give it to him. That would be amazing. And it seems like a great opportunity. It's not that any particular Attorney General wants to do it, but with 51 of them in the country, someone should want to do it. And the lead is right there on my website, ready for them. Many years ago, I used to get invited to conferences of attorneys general to give them leads, and I really would be giving them leads, and they'd bring some of the cases. We had some good cases and some good times there. I'd love to be back in the thick of that. Maybe I'm starting to get back into the leagues where my ideas and my leads are worth people listening to.
Well, we're definitely going to include that link on your website in the show notes. So yeah, hopefully folks are listening and reading, and or reading the AI transcript, having their AI read our AI generated transcript. I mean, that's okay too. We'll take that. So I guess end with any advice to founders or people who are building technology in this space, to stay clear of, your investigations and how to do things the right way. Any thoughts on that?
Yeah, it is really tough. When I was teaching MBAs, I was teaching during the period of just massive law breaking, sort of the rise of Uber and Airbnb, which was nuts. To see Uber, which was so totally illegal, Uber coaching the drivers. Why don't you have your passenger sit in the front seat so it looks like a friend rather than a paying customer? And that was actually a paid message from an Uber city manager to all of the drivers in his jurisdiction. And I have a copy of the message preserved on my site to this day. It was hard for me to teach MBAs, because a lot of them were starting to have ideas that were totally illegal. I vividly remember one student who came into my office. It's an Indian American student who said, the Indian American food that you get from a restaurant is just not the same. I know a bunch of Indian grandmas who are here. They could cook, right? And you just go to their kitchen and they'll hand you the food in a bag from the front door. I say, wait. They're here on tourist visas. They're cooking in just like a house. It's not a commercial kitchen. Do they have training on food safety? Are you going to pay sales tax? There's a bunch of stuff. And the kid looks at me like, why would I possibly follow any of those laws? I'm just going to do an Uber and Airbnb and do whatever the heck I want. And no regulator will chase me fast enough to stop me. And it was hard to tell them that they were wrong, because they weren't exactly wrong. They were sort of wrong, at least, but not 100% wrong. So it was very frustrating for me. I would love to tell founders that the only path is the straight and narrow. Actually, I think there's a certain amount of cheating that a certain set of companies can get away with. And for better or worse, if I was advising a friend or a student, I'd probably tell them you can cheat some companies some of the time and you'll probably get away with it. Doesn't mean you'll be proud of it. Doesn't mean you'll want to tell your grandchildren about it. And the risk is extraordinary. The risk can explode in your face in ways that are kind of hard to anticipate. I don't think the Phia founders anticipated that this particular set of violations would explode on them in the way that it has. With the benefit of hindsight, obviously, everyone can see where they were vulnerable. God knows I've made some mistakes too. I don't really like monsters in my closet. I don't see why any founder should want to have monsters in their closet. The straight and narrow is awfully tempting, if you ask me.
Yeah, I enjoyed talking to Tom Wright a few episodes ago, where he was saying, he's a great journalist and he sees a lot of this kind of stuff up close. And he's very frustrated by the you can just do things mentality, where they're pointing to possibly criminal, illegal behavior as something to be celebrated. I do not celebrate it either, and I agree. I think the risk is much higher than people realize. But I think that's a great place to leave it. I have a feeling, Ben, that we'll be talking again on this podcast about again. It may take a while for the long arm of the law to move, but I'm really glad that you spent the time to chat and catch up about this stuff with me.
Well, thank you. Thanks for your interest. Great to be back in touch. It's been too long.
It has. Thanks, Ben.